just ahead on Washington to Washington.
Why did you decide to take on states' rights at this moment in time?
When you see the National Guard sent into states without a governor's request, without any enforcement of any federal law being claimed for doing that, that is very disconcerting.
The issue of states' rights, a longtime cause of the Republican Party, now gaining support from Democrats in Washington state and across the country. Lawmakers from both parties are calling for states to stand up and speak up.
When things are nationalized, we don't have a voice. Our governor barely has a voice in D.C.
But not everyone is on board.
I think that currently there is more risk to your individual rights coming out of Olympia than there is out of D.C.
Also,
I don't relish the opportunity to sue the president, but I will fulfill my obligation and our oath to make sure that we're defending the Constitution.
as the number of lawsuits against the federal government grows,
It's been lawsuits flying just about every day, it seems. And it's very, very partisan at this point. I mean, exclusively partisan.
a database highlighting state litigation shows just how it's changed over the years. From the capital of Washington state to the capital of the United States, this is Washington to Washington. Hello and welcome to Washington. I'm Jennifer Huntley in Washington state. It's an enduring tension in the American experiment, the rights of states versus the power of the federal government. The system of federalism, where power is divided between a central national government and individual state or regional governments, has been core to the United States since the founding of the country. But that system isn't as straightforward as it sounds. The tension over states versus federal rights has fueled ongoing debate and become supercharged in the current political era. This photograph helps tell the story. More than 40 top lawmakers from 31 states, Republicans and Democrats alike, posing together in Columbus, Ohio. The photo was taken at the inaugural meeting of the Assembly of State Legislative Leaders, a new bipartisan group of state lawmakers that is calling for the federal government to respect states' rights. Smiling in the front row.
I'm Lori Jenkins. I'm Speaker of the House, and I also represent the 27th Legislative District.
Washington's own Speaker of the House, Lori Jenkins.
I'm Jamie Peterson. I am the Senate Majority Leader, and I represent the 43rd District.
And Senate Majority Leader Jamie Peterson.
Is it truly bipartisan?
Oh, absolutely, Matt.
The Democratic leaders from Washington state traveled to Columbus in December 2025 for the group's first meeting, joining a cause that for decades has been a rallying cry of the Republican Party.
Why did you decide to take on states' rights at this moment in time?
When you see the National Guard sent into states without a governor's request, without any enforcement of any federal law being claimed for doing that, that is very disconcerting. When we see now the federal government, the federal administration, attempting to affect the way we carry out voting, the voting system in Washington state and in other states, which has always been the responsibility of states, those things are far beyond where the federal government has ever gone.
We're both lawyers, but one of the things that was drilled into me in law school was the federal government is a government that has only the powers that were given to it by the states. The states are the entities in our system that have sort of general authority, subject to the Constitution, but have general authority for public health, safety, and welfare, and to do everything that they need to be good governments for the people.
Democrats and Republicans in states across the country are having similar discussions within their state legislatures. In Utah, Republican State Representative Ken Ivory leads the state's Federalism Commission, a bipartisan legislative group that assesses state and federal boundaries. The Utah Commission also attended the meeting in Ohio. Representative Ivory recently joined a Utah conservative think tank podcast to talk about the commission.
When things are nationalized, we don't have a voice. Our governor barely has a voice in D.C. But sorting out where things should be decided and putting structure over politics, it's not just about state leaders. That puts every citizen back in the game and through their representatives right where they live.
At a time when political debate is fueled by online anger, Senator Peterson says the initial meeting in Ohio was a test in diplomacy for those on opposite sides of the political aisle.
There was a sense in which we haven't exercised these muscles for a long time, and so there's a lot of kind of getting to know each other and sort of circling around to see what everyone thinks. So the biggest thing that we really accomplished was setting up some rules for how we were going to interact with each other, I would say.
The group plans to meet again this summer. Beyond resolutions and press releases, the meeting signaled a shift in how Democrats have viewed federal authority for years. And it isn't just the legislative branch that is pushing back.
This morning, the state of Washington, along with Oregon, Arizona, and Illinois, filed suit in the Western District of Washington against the President of the United States.
Democratic state attorneys general from across the country have filed a record number of legal challenges against the Trump administration, taking the lead on several issues.
I don't relish the opportunity to sue the president, but I will fulfill my obligation and our oath to make sure that we're defending the Constitution.
Washington's own Attorney General, Nick Brown.
The federal government obviously has immense power and has supreme authority over certain and distinct areas of our politics, our democracy, over our laws, but not over everything.
Since he took office in January 2025, Brown has led or joined more than 60 lawsuits against the Trump administration. In the 1960s, politicians used the doctrine states' rights during efforts to block federal civil rights laws. But Brown says the battle Democratic state attorneys general are taking on these days against the federal government is not the same.
How do you kind of reconcile that moment in history with states' rights and the moment that we're in now, especially as the first African American to serve as Washington State's Attorney General?
It is really easy to reconcile and distinguish. The southern states post-Civil War, all throughout the Civil Rights era, were trying to maintain their ability to discriminate and to harm and to enforce racial codes to make sure that white folks in those states remained in power and people of color remained out of power. That is a very different thing than states are doing now. And in fact, we are often fighting a federal government that wants to strip away equity and inclusion for people of color in 2026. And so I recognize, the tension there a little bit, but it's an entirely different moment for me.
Brown says his office is defending Washington residents against federal overreach on issues ranging from fair housing laws, environmental regulations, education funding, federal DEI initiatives, and Medicaid funding.
What we've seen is really an unprecedented amount of illegal behavior, unconstitutional behavior that I believe is purely un-American and coercive to our government, and that's why we've been so engaged.
He has also formed more than a dozen coalitions with other states.
Because of the breadth of actions that we're seeing from the administration, I think our coalition, our collaboration with other states is simply a reflection that no state can take this on by themselves.
Well, the United States Constitution puts it plainly that it enumerates a few things that the federal government should and must do, and everything else that is not enumerated in the U.S. Constitution is reserved to the states and the people.
One person who questions the intentions of state Democratic leaders is Republican State Representative Jim Walsh, who also chairs the Washington State Republican Party.
I believe that constitutionalists and conservatives are fairly consistent in talking about what federalism means and how it should be applied. It is the progressive left that is less consistent. It sort of selectively recognizes federalism when it suits political purposes and then ignores federalism when it doesn't suit political purposes.
Walsh believes the states' rights complaints these days are more political than valid constitutional complaints.
I think that currently there is more risk to your individual rights coming out of Olympia than there is out of DC.
And do you think the Trump administration has infringed on state rights in any way?
I mean, everybody always believes that any federal law or federal policy infringes on state prerogatives in some way. Okay, fine. I mean, is the current White House administration doing any differently than every other administration before it has done? No, it's not. Every White House administration has its own priorities, has its own agendas, and puts that forward, and the people get a vote on that. But when it comes to things like immigration, border enforcement, when it comes to things like national defense, those are responsibilities specifically granted to the federal government. And state legislators and a state governor can say what they want about it, but those are responsibilities duly given to the federal government.
Walsh serves as ranking Republican on the House Civil Rights and Judiciary Committee.
You have proposed measures to increase legislative oversight of gubernatorial emergency powers, limit government overregulation. How would you compare the work that you've done regarding constitutional compliance at the state level different from what Democrats are doing in challenging the Trump administration?
There are and should be reasonable, rational guidelines, guardrails, around the actions of the executive branch. And that doesn't matter whether it's the governor in Olympia or the president in Washington, D.C. The work that I do in Olympia on the Civil Rights and Judiciary Committee is to try to better articulate those guardrails so that we don't have the executive branch acting as legislative, executive, and judicial branch all wrapped in one office.
As for the state attorney general, while Walsh believes some circumstances may call for suing the federal government, for the most part,
this is a clown show. This is not serious policy. Attorney General Brown would be well advised to kind of take a step back, take a deep breath, and think seriously about when it is appropriate to challenge the federal government on serious matters of policy conflict and potential overreach. When you're suing the administration once a week, it becomes ridiculous.
What I would say to Jim Walsh is we have successfully protected $15 billion. $15 billion that would have otherwise been lost to Washington state agencies, to local governments that depend on funding from us, to nonprofit organizations. That is money for healthcare, education, natural resources, public safety. Every single one of our cases is based on, does this impact Washington state? Is it illegal or unconstitutional? And does it harm Washington state?
So how did we get here?
We are not involved.
There's always been tensions between the federal government and the state governments.
For a window into the history of the debate over state versus federal rights, we went to a source who has taught that history for 40 years, retired University of Washington law professor Hugh Spitzer.
It's really important to remember that the United States of America as a big country wasn't always that way. In 1776, you had a group of 13 colonies that were collectively seceding from Great Britain.
The new nation gave almost all power to the 13 individual states that were once British colonies, viewed as independent nations in the Declaration of Independence. The Articles of Confederation was the country's first governing document, creating a weak central government in favor of states' rights. States made their own money, set their own trade taxes, and controlled their own armies. The national government could not collect taxes or force states to follow rules. A shift came in 1787 at the Constitutional Convention.
And in that convention, there was a big debate about how much power the national government should have versus the states. People at that time really thought of themselves as citizens of Virginia or citizens of Massachusetts, not really citizens of the United States. And they were very concerned about the federal government getting too much power.
The U.S. Constitution was written and signed in September of 1787, creating a new framework for the U.S. government.
Remember, the people writing our Constitution in 1787 were doing something new. Nobody had ever done it quite like we were doing it, with one document trying to encapsulate the whole structure of government. And they had to make a lot of compromises when they were drafting it.
States had fought over money and trade. The Constitution established a shared balance of power by creating federalism, the system that shares power between the states and the national government.
One of George Washington's big complaints, of course, was that the state's contribution to the costs of his army were more or less voluntary, and the federal government really had no tax and revenue policy that was effective, and it kind of drove him nuts.
The federal government took control of making money, declaring war, and regulating trade between states. States kept the power to make their own local laws, run schools, and manage police and fire departments. And the Supremacy Clause in the Constitution was supposed to give clarity when federal and state laws conflict. The clause stated that the federal law is the supreme law of the land.
There was this tension in the Constitutional Convention between how much authority the federal government should have versus the states. They really had to compromise, and one of the aspects of compromise generally is that there are areas that are left unclear. And the allocation of powers between the states and the federal government were never clear and were never really meant to be clear.
But by the end of the Civil War in 1865, the balance of power changed yet again. The 14th Amendment gave the federal government more power to override state laws. Ratified in 1868, it reshaped the U.S. Constitution. Among the additions, granting rights to formerly enslaved people and protecting individual liberties from state overreach.
And then with the Depression, FDR became president, you had the New Deal, and there a significant increase in federal activity, both in terms of the economy and social services. And then that federal government grew again exponentially during World War II. And so it's really in the mid and late 20th century that we've had a big federal government like we have today. But the states have continued to exist throughout that period and been very active in very many ways.
Throughout the 20th century, federal authority would be put to the test.
During the Civil Rights era, we saw southern states challenging federal activities to push the civil rights of African Americans. Then during the Obama and Biden administrations, we saw Republican attorneys general primarily challenging programs that they thought were improper for the federal government.
This is a lawsuit about the constitutionality of some of the provisions in the bill.
Over the years, people in both state and federal courts have challenged what is known as a living document, the Constitution.
The Constitution is structured so that no one gets too much power. Not the federal government, not the state governments, not Congress, not the executive. Really, if the states are unhappy with what the federal government is doing from a policy standpoint, they're going to make use of provisions in the Constitution and court cases that are going to enable them to try to block the federal government. That's how it's supposed to work.
That's the system.
That's the system.
At the meeting in Ohio last December, Democratic and Republican lawmakers adopted a joint statement on federalism, calling for, quote, the respect of the constitutional division of powers between the states and federal government, opposing federal preemption of state laws, and urging the federal government to take action to preserve the states' role as laboratories of democracy. And in July 2026, Washington Governor Bob Ferguson and state agency directors spoke out against changes to rules regarding federal financial assistance. They called the proposed changes federal overreach that prevents Washington state from administering federal money and grants in a timely manner. Well, nationwide, Democratic attorneys general have filed a record number of lawsuits against the Trump administration. But lawsuits against the federal government and industry are nothing new. The history of legal battles between states and the federal government shows that state-led litigation has grown significantly in the past several decades.
Well, I started getting interested in the state attorneys general back in 2007, the tail end of the George W. Bush administration.
In his office just blocks from the U.S. Capitol in Washington, D.C., Marquette University professor Paul Nolet has been tracking and studying multi-state lawsuits against the federal government for nearly 20 years. His interest first peaked about a decade after the largest civil settlement in U.S. history in 1998. The tobacco settlement, which found tobacco companies engaged in deceptive marketing practices and hid the health risks associated with smoking.
And it really reshaped the entire industry, sent billions of dollars, and is still sending billions of dollars back to the states.
In 2007, the political science professor started his research with a question.
What have the AGs been doing in the meantime since the tobacco litigation? And it was almost like peeling back layers of an onion over the next few years, because they've been working on issues pertaining to the financial sector, pharmaceuticals, all of these different issues, in addition to getting more aggressive against the federal government.
The process was time-consuming.
But when I started that database, the purpose was really to fill a gap that wasn't out there, that really hadn't been collected before.
He ended up looking at cases as far back as the 1980s to get a complete look at the evolution of state legal challenges. Nolet began sharing the information in a database 5 years ago. What it showed initially was a bipartisan effort, states coming together to fight industries.
There were a lot of consumer protection cases. There was some inklings of some partisanship that were taking form even as early as the 1980s. But for the most part, the multi-state campaigns were targeted at corporations and largely bipartisan.
This culminated with the tobacco litigation and a settlement focused on the health care costs from smoking. The case was a clarion call to states that they can be successful in taking action against industries that harm their residents. What followed? Action against the pharmaceutical industry, including during the opioid epidemic, that was successful in bringing in nearly $60 billion to states. But at the same time, Professor Nolet noticed a slight shift in the focus.
I'd say right around the time that I started researching AGs in the last couple of years of the Bush administration, W. Bush, that's when we started seeing some additional partisan behavior. There were Democrats like Eliot Spitzer, who were very aggressively targeting the Bush administration on a number of issues. And it really wasn't until the last couple of years of the Obama administration that Republicans also joined in the multi-state world and became more aggressive in suing the Obama administration and agencies much more aggressively over a whole range of issues.
Nolet says partisan cases skyrocketed during the first Trump administration.
When Trump came into office in 2017, that's when Democrats escalated the multi-state activity quite dramatically, and we saw just an enormous amount of litigation during that first term of Trump's. And in fact, we saw as much multi-state litigation in those 4 years that we saw in the previous 16 years of W. Bush and Obama combined.
And it didn't stop during the Biden years.
It was very much an escalation. Republicans continued that during the Biden years, and the last year and a half, the first portion of the Trump administration, it's been lawsuits flying just about every day, it seems. And it's very, very partisan at this point. I mean, exclusively partisan. And so it's been an evolution over time.
Nolet's research shows how states have increased their challenges to federal power and corporate influence over the years.
It's almost like a boulder gaining steam down the hill. It's gotten a lot more common over time. And I do think that a big reason for that is really AGs fully discovering the tools that they have and taking full advantage of those in ways that they hadn't in years past.
And states are getting more sophisticated in their tactics, teaming up and forming coalitions that allow them to pick and choose where cases are heard.
A lot of times Democrats will sue in places like the Northern District of California, San Francisco, Southern District of New York, Manhattan, and then more recently, anywhere in the First Circuit, which is essentially most of New England, because there are more Democratic appointed judges in those areas. Whereas Republicans go to Louisiana, Texas, and Florida. So they seek out more Republican judges. So that sort of forum shopping has been a big factor, I think, in their ultimate success.
If they build these coalitions, to what end?
Washington State Congressman Michael Baumgartner believes the coalitions are creating more division in an already divided country.
Look, I'm a conservative Republican from Eastern Washington, so a lot of times we don't feel that we necessarily get the representation that we're due. And so if our state lawmakers that control things, the liberal Democrats in Seattle, are looking to care more about what's happening in San Francisco or Portland than they do what's happening in, the Yakima Valley or Spokane or, down on the peninsula, then I think they're doing a disservice to the state. So that's the coalition they should be building within the state, I think, not now going down the West Coast.
Despite 3 federal shutdowns during the congressional budget process, Baumgartner believes Democrats and Republicans can come together in Congress. Nolet says part of the reason why state attorneys general are fighting back is the increase in executive governing at the federal level.
When you think about the presidency, executive actions, executive orders have been around for a long time. I mean, FDR used a lot of them. But in recent years, we've seen presidents, both on the left and the right, use executive orders much more aggressively on major policies as well.
Those executive orders are vulnerable to legal pushback, especially in instances when congressional authorization may be needed. But in the end, it is the friction that makes up the system of federalism in the U.S., uniting and dividing at the same time.
That sort of overall states pushing back on the federal government, that's a persistent feature. And I think as long as the United States stays a federal system and keeps the Constitution, then it's going to continue.
To view the entire database of state litigation and AG activity over the years, you can go to attorneysgeneral.org. I'm Jennifer Huntley. We'll see you next time on Washington to Washington.